All right, guys, some of you have asked me why I haven't been around for the last few days doing videos. It's because I've been reading this. This is the pile of the briefs submitted by the government and their friends in support of gun control by and large in the Rahimi case. But today we're going to talk about the First Amendment and the Gadsden Flag. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gunner and constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gun Owners, the A to Z book about how the anti-gunners intend to take our rights away bit by bit. It's an extremely detailed book. Check it out if you don't already own a copy of First They Came for the Gun Owners. All right, folks, so we've seen in the newspaper, I'm sure other people have covered this. I've been gone for the last couple of days. As you know, basically I've been around, but I've been trying to get through all the Rahimi stuff to figure out what I'm going to say on this channel and whatnot. There's a lot of things to consider, but we're going to really break it down in extreme detail for all you guys, make it understandable and coherent, and explain why the government's wrong. But as you can see, there's thousands and thousands of pages of materials that have to be gone through. That's just the briefs, never mind the citations and the information they cite to, and so on and so on. But I still wanted to get to this great story about the 12-year-old schoolboy who wore a Gadsden Flag patch on his book bag, I think, in Colorado Springs as part of within the Harrison School District Number 2 as he went to a charter school known as the Vanguard School. Now, what's very interesting about this, you probably have all seen the video, you've seen people talk about it, but I want to talk about it generally speaking from a legal perspective. It is pretty clear to me that the school had this wrong because there is a long-standing Supreme Court precedent that I want you all to know about. It's called Tinker, T-I-N-K-E-R, Tinker versus Des Moines Independent Community School, 1968 Supreme Court decision dealing with the First Amendment's right to free speech. In this famous case, it said that students, in this case high school students in the Tinker case, students do indeed have First Amendment rights, which means that the public schools, which the Vanguard School, I believe, was a public school in the sense it was a charter school governed overall by the state or by the town, the municipality, but technically it was still a public school even though it was a charter school. But the Tinker case in 1969 by the U.S. Supreme Court said that students do have First Amendment rights. In the Tinker case, that dealt with I think it was like 5 siblings that wore shirts to school, and every shirt had a black armband. And the black armband was significant because it represented a protest to the ongoing war in Vietnam. Now, these students got into some hot water with the administrators in the school. They wound up suing. To make a long story short, it went to the U.S. Supreme Court, and the Supreme Court says the right to free speech, the right to freedom of expression, does indeed trigger to students in schools, and they have a right to speak out. And schools do have the right to come up with content-neutral rules and regulations. For example, they could say no one is allowed to wear a hat. They could do that, and no one would be allowed to wear a hat. And if you wore an NRA hat, let's say, or a gay pride hat, you would not be allowed to wear that because it's not about the content that's being discriminated against. It's the fact that you're wearing the hat. So again, here there was no dispute in this Harrison School District case or the Vanguard School case involving the Gadsden Flag about that you couldn't wear patches. Like, you could have patches, you could bring patches, you could put them on your shirts, apparently you could have it on your book bag. It was the content of the patch that was objectionable to the school and the school district, at least initially. Now, as you all know, the school has now backtracked and said that the patch, the Gadsden Flag, is allowed to be brought in. It's perfectly fine, and they are not going to discriminate on what's known as viewpoint discrimination because they can't under the First Amendment in the U.S. Supreme Court case of Tinker. Now, I should say that there are exceptions to the rule of students having First Amendment rights. Again, one of them, as I've already mentioned, is if you can have a content-neutral rule, like everyone has to wear a school uniform with a tie. Well, that would be enforceable. That's not a violation of the First Amendment because, again, it's a uniform rule that's not driven by content. No one can wear a hat. Perhaps there's a rule that says no one's allowed to wear T-shirts. Again, as long as it's content neutral, those are generally allowed under the First Amendment. Now, there is another exception called the disruption exception, which basically says that if there's some communication or message that could cause a disruption in the school day, because the purpose of schools is to educate and to teach. And if there's something that you've done that creates a disruption, then it's possible the school could prevent the communication. So, for example, if you stand up in the middle of the library when everyone is studying and start chanting some message, they can say, look, you're disrupting the students here, and therefore we can stop you from screaming or yelling or protesting because you're disrupting the school day. Now, as to what constitutes a disruption is often fact-intensive and subject to debate. So we don't need to get into all these now, but certainly the wearing of a patch of an American Revolution War symbol doesn't seem in any way, shape, or form to rise to the level of disruption. And obviously, in this case, the Vanguard School and the Harrison School District Number 2, which I believe is the relevant school district here, certainly they agreed and backed down after the student was told you couldn't wear a patch. Now, I should also say that what is also significant to the Second Amendment here, in addition to wearing pro-Second Amendment gear to school, the other interesting thing is the excuse they gave for why this patch was not allowed. The teacher or administrator who was in the video that I saw was explaining that there was concern that the patch was associated with slavery, which obviously is not true because the Gadsden flag is, of course, don't tread on me. It's a basically pro-American revolutionary view against the tyrannical British monarchs for all the detailed reasons set forth in our Declaration of Independence in 1776 of all the terrible things that King George III and his swarms of people and mercenaries and agents were doing to the American colonists. So it had nothing to do with slavery. But I do want to flag something I've talked about on this channel before, and some people have harassed me about this. I've explained to you, and I did this like almost over a year ago at this point. I've said, look, the anti-gun movement is going to try to paint the right to keep and bear arms as a pro-slavery position. They're going to try to argue, because that's what certain professors are doing, not persuasively at all in my opinion, but they're out there right now getting published in law review articles and doing books and so on, where they're literally trying to make the case that the right to keep and bear arms, as codified by the Second Amendment's right to keep and bear arms, somehow ties into maintaining slavery, advancing slavery, protecting slaveholders, and so on. And these arguments are out there, and we need to combat them. And just as a quick reminder why this is clearly not true, that anything is pro-Second Amendment, the Gadsden Flag, and all this, none of these things have anything to do with slavery, is because, remember, our right to keep and bear arms comes originally from the late 17th century English Declaration of Rights, involving the attempt by the rabid Catholic King, James II, to try to disarm the Protestants. And after there was a overthrowing of James II with William and Mary, it turns out that they adopted the English Declaration of Rights that said that the Protestants had the right to keep and bear arms, and the government could not take those away. And it was sort of from that initial concept that we get our Second Amendment right to keep and bear arms. And why this is particularly important is, at the time of the English Declaration of Rights, there was no substantial or material slave population at all in England, which really puts the lie to the notion that our right to keep and bear arms has anything to do with slavery, because it comes from England, the late 17th century, which again, there was no material slave population at all in England. I think maybe there may have been some slaves at ports or something, maybe, but generally speaking, it was a Protestant Catholic issue from which we get our right to keep and bear arms, ultimately in the Second Amendment. Moreover, one of the great abolitionists, the former slave Frederick Douglass, about, of course, this channel was effectively kind of adopting some of his views. The Four Boxes Diner is, of course, based on the Four Boxes of American Liberty, which is the jury box, the rule of law, law. There's the soapbox, the right to speak out, the ballot box, which is, of course, is the right to vote, and last but not least, the cartridge box, which is the right to bear arms. Frederick Douglass talked about 3 of these 4 boxes. He did not talk about the soapbox, but he talked about the notion of, to be a citizen in America, you need access to all of these boxes. And it's quite interesting that there is an attempt to try to equate the Second Amendment's right to keep and bear arms with slavery, even though one of the greatest abolitionists of all times, Frederick Douglass, was a huge proponent of the right to keep and bear arms. And as you know, Justice Thomas in the Bruin decision talks about the fact that the Dred Scott says that blacks cannot be full citizens because if they were full citizens, they could bring their guns everywhere they went in the Dred Scott decision. But Clarence Thomas points that out and uses that to advance our right to keep and bear arms in the context of NYSERPA versus Bruin. And the only other point I want to make about how it's absurd to suggest that anything associated with the right to keep and bear arms is somehow tied in with slavery. Keep in mind that some of the biggest states that wanted the Bill of Rights, and just to jog your memory, the Constitution was adopted originally without a Bill of Rights, but with an understanding there would eventually become a Bill of Rights, because there was debate whether or not you even needed the Bill of Rights, but ultimately they decided that we should have a Bill of Rights, and some of the states that were the biggest proponents of the right to keep and bear arms was not the southern slave states. There were states like Pennsylvania, New Hampshire, Rhode Island, New York, and Massachusetts. Obviously, these were really anti-slave states. They did not have slaves, and these were northern states at the time of the founding, and yet they wanted the Bill of Rights, which really, to me, puts the lie to any suggestion by anti-gunners that the right to keep and bear arms in the Second Amendment was all about maintaining slavery or slave raids or fugitive slaves or putting down slave revolts, whatever you want to say about it. It's pretty clear that the right to keep and bear arms in the Second Amendment has nothing to do with that, because if you look at the states that wanted it, it was the northern states that did not have slaves. Now, I don't know the young man that's involved with this. I don't know his family. I don't know the lawyers. I don't know anything out there in Colorado Springs. With that said, if I were representing the family or the young man, I would be thinking about collecting damages under the civil rights law, specifically 42 U.S.C., 1981 through 1988, specifically probably 1983. We don't need to get into those geeky details for the purposes of this video, but what I would say is this. I would be very curious if the Harrison School District number 2 or any of the school districts that touch fingers with this particular issue and this patch issue, I would be very curious to see in March 14th, 2018, when they had the post-Parkland shooting high school and school March for Our Lives propaganda campaign in support of gun control. If I were representing them, I would look very carefully to see whether that district approved in any respect the March for Our Lives, the gun control movement, or any of those efforts in March of 2018 to let students leave class to protest in favor of taking away civil rights. Think about how crazy that is, right? Nevertheless, that would be very interesting, because if it turned out that some of the people involved with this patch incident were somehow tied in or allowed students or encouraged students to protest in favor of gun control on March 14, 2018, well, that might just be very interesting in terms of potential damages, because you really are showing that those agents, those government actors, may really have a bias against the right to keep and bear arms. They may really have a bias against the Bill of Rights or civil rights, whatever it is. I'm not framing the whole case up right here in this video, but I do think that might be kind of an aggravating circumstance that would make this alleged violation of the young man's First Amendment rights a bit more egregious. But again, I'm not out there. I can't speak to that. I can only speculate. But that's the sort of thing I would be doing if I were the counsel and involved in that situation in Colorado Springs. But at the end of the day, it looks favorable that he was allowed to continue to wear his patch. Personally, I'm more of a Battle of Benitez flag fan. But nothing wrong with the Gadsden flag. Obviously, no complaints about that at all. Don't tread on me. Perfectly fine viewpoint. I have no problems at all with that. Okay, folks, hope you learned a little bit something here today. If you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.